I'm Lisa Shepard, and I am the Executive Director of the Chief Justice's Commission on Professionalism. The mission of the CJCP is to enhance professionalism among North Carolina lawyers, judges, and law students, a mission which it has been doing since 1998. One of the ways that the CJCP does this is to sponsor this historical video series, which is a collection of video interviews of distinguished lawyers, judges, and professionals from across North Carolina. The CJCP began filming these video interviews in 2000 as a means to preserve the thoughts of these bar leaders on the legal profession and on professionalism issues. All of the videos in this series are available to you on the CJCP website and the CJCP's dedicated YouTube channel. We are so fortunate to have had many distinguished members of the North Carolina Bar over the years, and they have much accumulated wisdom to share with us. It is important to understand that the practice of law is a profession, and doing it well requires not only substantive knowledge that one gains in law school and from studying for the bar exam, but also the value of experience learned from other lawyers. I hope that this video series will give you not only a fresh insight into the person being interviewed, but also some meaningful information about how to be a better lawyer in your own practice. Enjoy, and remember, esse quam videri. Strive to be professional in all that you do, rather than to merely seem so.
Hello, I'm James E. Ferguson II, a member of the law firm of Ferguson, Stein, Chambers. The Chief Justice's Commission on Professionalism has asked me to do this introduction for Julius Chambers, my longtime partner and longtime friend. Julius Chambers is one of the nation's outstanding lawyers. He has built a career in civil rights law and civil rights work. He is truly one of the most outstanding jurists, not only in North Carolina, but in the nation. His career has been a career of firsts. He was the first editor-in-chief of African descent of the Law Review at the University of North Carolina Law School. He was the first intern in the NAACP Legal Defense Fund's internship program, a program designed to encourage black lawyers to return to the South to do civil rights work. He established the first integrated law firm in the state of North Carolina. I am proud to have been one of the founding members of that firm along with him. His courtroom work is legendary in the areas of school desegregation, voting rights law, and employment law. He argued successfully the famous Swan versus Mecklenburg school system decision, where school educational opportunities opened up for African American children all over the state of North Carolina. Mr. Chambers has served as Director Counsel of the Legal Defense Fund. He has served as Chancellor of his alma mater, North Carolina Central University. Most recently, he is serving as the head of the Civil Rights Institute of the University of North Carolina Law School at Chapel Hill. It is a great pleasure and honor for me to give you a glimpse into the life, the career, and the mind of Julius Chambers as part of this special edition of the historical video series.
I think we should all think of law as an instrument that permits one to serve his or her fellow person. I started years ago with an incident involving my father that has really bothered me throughout my career, but it also was a basis that led me to want to go to law school and to become a lawyer. And my father was a mechanic who finished the 3rd grade, but he was a good mechanic, and he did some work on a truck that belonged to a leading white citizen of Mount Gilead, North Carolina, and the gentleman wouldn't pay him. And my father wanted to bring a lawsuit because the money he had worked for, he wanted to use to send me away to boarding school. And my father couldn't find a lawyer in North Carolina who would represent a black person in a suit against a leading white citizen of Montgomery County. So he had to pass up that opportunity. I had to pass up the opportunity of going away to boarding school. But in the process, I felt that I could go to law school and could get out and could serve people, and particularly black people in North Carolina who desperately needed legal assistance with many of the problems that they were encountering. And I committed then to go to law school to do just that. At Chapel Hill, I was in the second wave of black students who enrolled in the law school at Chapel Hill. Harvey Beach and Kenneth Lee, among others, were in the first wave who really integrated the school. And I came along in 1960, 59. And at that time, the school really wasn't that prepared to receive black students. And we had a lot of interesting experiences with relationships with white students and white faculty members. I was first called in by the dean, a person I greatly admire and admired, Dean Henry Brandes, and I was told that I shouldn't attend any social events at the law school because they weren't ready for me to attend those events, and I should not attend any dances particularly. I was also told that I shouldn't try to date, I wasn't married at the time, any white female students, and I did not. But those two experiences told me that we weren't ready yet at Chapel Hill for an integrated experience for students or faculty. We had no black faculty at the time. But I learned a lot in that experience, and I also met a lot of people with whom I've had to work since leaving, and it was a great experience. It was possible to work within a system and effect change, that we could, through dialogue, talk with people who were ardently opposed to some of the things we were advocating, like equal opportunities for African Americans, and work out arrangements that would permit African Americans to enjoy those opportunities. I also appreciated through that experience that it was not going to be an easy proposition. We had a number of instances where we were clearly told that we were not wanted, and we knew that as we went about our efforts to try to make sure that there were better opportunities for the group of minorities who followed us. When I left law school, law practice was rigidly segregated. I don't know of a black lawyer in any major white law firm anywhere in the South, not just in North Carolina, but anywhere in the South. I went around the country in Washington and New York, as well as in North Carolina, talking about possible job opportunities, and they just weren't there for a young black lawyer. That's one problem. Second, I had made the commitment long before that I was going to go to law school and get out and provide legal assistance for African Americans who desperately needed legal assistance. So I was able to get out and set up a practice and provide needed assistance in North Carolina, and it was something I will always really be proud of, because I think we helped a lot of people in the process. It was a real challenge, I think, for black lawyers as they began practice, and for those who had been in practice for some time. I think it was Judge Craven who told a story about a judge saying that he thought he had really made progress because he even allowed some black lawyers to practice in his court. Well, it wasn't quite that bad, but it was still pretty bad. Black lawyers were first not that plentiful in North Carolina. We didn't have that many black lawyers in North Carolina. And those who were able to practice were not that well received, and they really had to fight for everything that they got. White lawyers, on the other hand, had some struggles themselves, but nothing like those that black lawyers had to face. And white lawyers were pretty representative of the attitude of whites in the state and in the South. They really were not that committed to opening up opportunities for African Americans in the various walks of life. And I was in an area of practice that attempted to force or encourage others to accept the rights of African Americans to exercise the same kind of opportunities that whites were enjoying. It really interested me to make the comparison with the earnings of black lawyers and white lawyers, and we were really making meager income as compared with the income that whites were making. We didn't have the same opportunities to dream about judgeships. We had no black on the federal court, or at that time even on the state court. We had no black prosecutors, and we were almost totally excluded from the judiciary system. And white lawyers accepted that. Black lawyers were very disturbed about it, but I think through the persistence of black lawyers and of white lawyers, we began to see some breakdown in that kind of practice. One thing I always tried to do, and I think I had some success with it, and that was to make sure that I was really prepared when I went to court. I would read, I would basically know the law that I was trying to employ. I would know the facts, and I would know something about the lawyers I opposed or who were opposing me. And I think black and white lawyers respected the preparation that we put into preparing for each case, whatever the merits or whatever the facts of a particular case. I think they had to respect the fact that one was prepared, and second, that one was able to articulate the facts and to articulate the law. We had a kind of judicial climate that I think encouraged judges to fairly weigh evidence and to make decisions based on the evidence that was presented and the reasoning of the arguments that were presented. And based on that, we were able to succeed with a number of the cases that we brought. But I knew, as I'm sure most lawyers knew, that being black was not the most receptive role for one to be in the state or federal judiciary. But it was a problem that we knew we had to deal with, and we did. There were numerous times when I was very disturbed with the conduct of judges or the conduct of opposing counsel. And one of the things I learned was that in the face of that kind of conduct or practice of people, a person prepared with his or her case and his or her facts, and who's more interested in reasoning than in trying to fight with an opponent, is in a much better position to control what goes on in the court proceeding and in the case for his or her client. I think in the instances where I really got riled, I tried very hard to make sure that I did not show how I really felt about particular things. I also tried very hard to make sure that as I talked, I was careful in what I said and the way that I said it, in order to make sure that I was communicating with the person, whether or not he wanted me to communicate or she wanted me to communicate. I tried to show examples of what could be done in order to accomplish the objective that I was advocating. And I think that sitting down reasoning with people was much more effective than anything else that one could do under those circumstances, and I think it worked. So sure, I got riled. I think a lot of people got riled. Sure, I felt very strongly about some of the experiences that I had, but I knew throughout that it was far better to sit down and reason than to try to fight with a particular opponent. And I think that has a much better success rate. I perhaps wisely or unwisely did not pay a lot of attention to threats and even some practices like the bombing of an automobile. I often wondered who was behind particular incidents, but because I wanted to sit down and talk with them, but that wasn't possible. But I think that when you have people who act unreasonably, that you do the best you can to state your case, and then you move on, and somewhere you depend on more sound reasoning coming to people. And I think that works as well. I watched, and it's really been interesting to me to come back into practice after about, 16 years away from North Carolina, and to listen at people who, when I was in practice back in the 60s, were ardently opposed to integration, who now advocate that things ought to be integrated. There's obviously a limit to where they go, but that to me is progress. And I think that more reasoning like that we engaged in over the years can be very helpful in encouraging others to come along and to act more reasonably in what they do or say. I think that we have people who throw bombs or burn down buildings when they don't know how to communicate their concern. And I think we appreciate that, and we address it, and we will have a lot more success in dealing with it. I had a commitment long ago to try to carry on the struggle with all the people who were committed and capable of helping one carry on the struggle. And I knew that one could be much more effective with an integrated law firm, for example, than an all-black or an all-white law firm. And I thought it was progress when we could get black and white people together to work for this cause that we all felt was extremely important. So in that sense, we deliberately tried to encourage white and black lawyers to come together with it. I remember also that this was sort of personal. I had the great experience of Jim Ferguson and Adam Stein coming to practice with us one year, and seeing two, to me, great minds and at work with a real commitment to a cause, and being able to get them together in a law firm was like a dream. And it was extremely enjoyable for me to be able to tell someone that I had Jim Ferguson and Adam Stein associated with me in a law practice. And along came Jim Lanning, and later we had a number of others who really helped, I think, with the work that we were trying to do in North Carolina, and I think have helped to bring the kind of reputation of the firm that the firm has done. We all do much better when we bring everybody into the chamber and listen to ideas from all people. We appreciate more how whatever we decide to do will affect people and can be helpful. We learn more from people from different races and experiences. And I think whether we are operating on a brain or preparing a case for trial in the U.S. Appeal in the U.S. Supreme Court, we do much better when we bring people together without consideration of race or gender or religion, and give everybody a chance to say something and to have an input in whatever decision we pursue. We civil rights lawyers had undertaken, in order to obtain as much desegregation of schools as we could. I remember back in the mid-60s, as we talked about Brown versus Board of Education and what it meant and how it could be or should be implemented. And we had a real problem with whether you can include busing of students as a part of a desegregation order. We knew that you couldn't really integrate many of the schools unless you were including transporting students as a part of that process. We also knew that the Supreme Court had been very reluctant to move forward with desegregation. It had issued a precedent-setting case with Brown versus Board of Education, and then had sort of backed out off in terms of what that meant and how do you implement it. And we had worked, I think, very diligently in trying to marshal the facts to convince the court that the only way we could enjoy what the court had said about Brown versus Board of Education was to obtain the kind of order that we advocated in Brown and Swan, Charlotte, Mecklenburg. Second, I think that a lot of people in Charlotte and in Mecklenburg County feared that Brown was just some language that the court had used without any real teeth. And a lot of people really wanted to see black and white children get together and black and white parents get together. And they feared that if the court did not direct the kind of relief that was ultimately directed, that we would have a major decision like Brown with no teeth. And it was important for the community in that respect. It was important for the leaders in the community, and I think it was important for the civil rights community to have the Supreme Court deciding Swan the way the Supreme Court decided it. Third, I think that we had some people in Charlotte who were ardently opposed to desegregation, and a lot of people who really believe in obeying the law, and they simply needed a court to help them understand what the law was. And this is an objective that we tried to achieve with that decision. So we had a number of objectives with the case, and we were really excited that we had a decision the way that the Supreme Court came out with that decision. I don't think in this day and age that we will ever return to the segregation we knew back in the 60s. I think African Americans have been experiencing educational opportunities that they will not easily give up. I think whites have been experiencing opportunities that they will not easily give up. I think most lawyers with whom I have had to deal believe that the court has correctly interpreted the law. And so I doubt seriously if we will ever return to the kind of situation we knew back in the 1960s. There is a real danger that schools in Charlotte-Mecklenburg will open with a heavy concentration of blacks in one school and a concentration of whites in another. And that may be there for a period, but I don't think that system will last, and I think we will have different results in what we all fear right now. But I could be wrong, and if that happened, I would be very concerned. But I see so many other things happening that suggest to me that we may not have the return to the Charlotte segregated system that you and I knew back in 1964. For example, we're now talking about the voucher system. We're now talking about charter schools. We're now talking about the ABC plan and any number of different things taking place that can have an effect on what will ultimately happen with the way that we operate the schools. And I think those things are taking place at a time when people have appreciated that desegregation of the schools has meant so much to all of the people in the system that they will not easily give up the kind of desegregation that they knew. So, sure, we may get some heavy concentrations of blacks and whites in different schools. We may have a real threat toward a return to what we knew back in the 1960s, but I doubt seriously if we will actually have what we saw in the 1960s. I think Griggs was like Brown. It was the first major substantive interpretation of the anti-employment discrimination law, and it really helped with the implementation of Title VII, and I was really excited with the result. And I think a lot of people were excited with the result. We had a decision that really told us how Title VII was to be interpreted. And we saw that using that interpretation, we'd be able to accomplish a lot more with Title VII than many people feared. So it was a great decision. And then, you know, none of these decisions have come down in a vacuum. One has to know the plaintiffs in the Griggs Duke Power to really appreciate all that it meant. We had a number of black employees, about 14, about all that Duke Power had hired at the time, who wanted to be operators of machines in the Duke Power facility. Many of them hadn't gone to college. Many of them hadn't even finished high school. But they were just as trained as the white employees who were operating the machines. But they couldn't gain employment in those areas because they were black. And the court ruled that they should be allowed to gain employment just like white employees, and it really meant a lot to them personally to have that kind of opportunity. So, and then the third thing is, it really meant a lot, in my opinion, to Duke Power, because Duke Power got a lot more trained, competent people to work in that facility than they otherwise would have. I knew that Justice Scalia viewed a lot of these cases differently than I, and that he looked at arguments and as a means for trying to advance some causes that he supported or believed in. I was a bit disturbed with that question, but you know, I really had been prepared for that question from an earlier argument when Justice Stewart asked me, I believe it was in one of the school desegregation cases, if I was sure that the people I represented really wanted integrated schools. And what happened was that a group had filed an amicus brief arguing that they didn't want buses, and that group included black and white people in that community, or some black and white. But Justice Scalia asking, what do you people want? That's the way he phrased it. And I couldn't help but be a bit disturbed with this question, because it should have been pretty clear what we wanted, an opportunity to vote without consideration of race. But we have justices on the Supreme Court who think like that, who are a bit more conservative than we think our justices should be. And again, though, it helps for one to maintain one's cool in the heat of these kinds of discussions, and respond with something that will be helpful with the court's decision. I did not think we had advanced all that we would be able to advance with the Legal Defense Fund, but we had made some progress. We had some good people at the Legal Defense Fund who would be able to take the Legal Defense Fund to far greater heights than anything I had been able to do. I think Elaine Jones has moved in and has done an exceptional job with it. I also knew that we had a lot of good people in the field who would continue their support of the Legal Defense Fund. And my opinion is that somewhere along the way, one ought to appreciate that no one is irreplaceable, um, that there are others who can do as good a job or a much better job with issues than one can. I think one becomes somewhat stale in a position at times, and I like to assume that any public position like the Director Counsel of the Legal Defense Fund or the Chancellor of a university um, should move on after about 5, 6 years. I was told that North Carolina Central University was in a crisis and really needed someone to help address a real internal, external crisis that the school faced. And I had graduated from Central, and I knew a lot of people there and a lot of people in the state. And I was told that I could be of help in bringing some stability to the school and offering some opportunities for it to advance. And I felt that kind of commitment. First, I think it is extremely important for everyone to read as much as one can and to become knowledgeable about the subject matter and about the facts. I spent a lot of time during law school in the library reading cases, analyzing cases, understanding something about judges, and I found all of that very helpful, in fact, sort of essential. And I think law students ought to take a moment, or a lot of moments, and learn a lot about the way the court operates and the law. Second, I think that we shouldn't think of law in isolation. I don't care what particular area one is in. We have to think about the applicability of law to people. And people make the system work. And if we apply legal principles to a particular fact situation, we're applying it to people. And so one has to understand people and how people work and react to different things. The third thing is, I think it's crucial for all of us to understand that we are talking about the greater good for all people. It is important in representing a client to do everything possible to help that client. But I think it's also important in any particular case to do things that will be helpful to the broader community. And certainly if one is dealing with constitutional issues or public interest issues, in my opinion, it's important to make sure that we are advancing the public interest in the process. And I think students need to read and look at what helps with the greater good of the people as they pursue their studies and what will be helpful in the litigation that will follow. It is not a profession, in my opinion, for folk to just make money and get rich, but I think law is its noblest and is serving its people best when it is providing service and opportunity for the folk who are being served by it. And if I were coming out of school today and was dreaming about how I could be of service to people, I would think that I would be pursuing the noblest kind of practice that we have heard from Charlie Houston and others about what role law should really play. We talked about the need, we talked about opportunities that we have to help promote. And we're talking about the need now because we are carrying out the noblest objective of law.